Hmm? Okay. Hello?
And so, based on what we got from the survey, we're going to be treating those questions, and Babade will be answering those questions. Okay. So, firstly, I want to ask, what are the common misconceptions by landlord and even tenants, as regards tenancy law, or as regards tenant and landlord relationship? What are the common misconceptions that we have, that landlords and tenants have?
Okay, yeah, thank you very much. First, thank you for having me. And then second, I want to thank everyone who made that time out of their busy schedule to be here. Especially on the Sunday evening when you should be sleeping and resting for the week. You're all here on this call. So first, start by saying thank you to you. Yes, so to the question, there are a number of misconceptions that landlords and tenants have. And then into it varies from, so there are some landlords who think that they can do and undo to any tenant. So you have landlords who, for example, would block the sewage pipe of the tenant, or some landlords that will remove the door of the tenant's house, or landlords that will remove the roof and things like that. So that's what some landlords think that they can do and undo. That once you're a tenant, you can do and undo. Then some misconceptions some tenants have. One is that there are some tenants who believe that once you have served the notice to quit, then the landlord does not have any right to collect rent from you. So or some people believe that you must give them 6 months rent free, compulsorily. So that's one misconception that a lot of tenants are not knowing that you have to pay for every day you are in a house. You have to pay for it. And even when you are given a notice to quit, you are still meant to pay for the period of time between you're given the notice and when you leave. So that's just one big misconception on both parts. But I'm sure those who are on the call, if they have any questions or clarifications, I'm on ground to clarify or answer that.
Okay, okay. Thank you so much. Okay, so
You're
another
welcome.
one to ask you, a general question is as to tenancy agreement. What are the guidelines? Or let me start off from, uh, there's a trend that I've noticed that people, Mr. David said he can't hear anything. Can you hear me now?
I want to presume it may be a personal issue. So, but we can just
Okay,
ask if
maybe a
there's another
personal thing.
one person who can't hear, can just type in the chat box, or if you can hear, just type yes, I can hear, so that we can know that probably it's an issue with David's device. He can log off and then log in back again. Uh, okay, yeah. So JCA said he can hear us. Um, okay, so I think it may be an issue with David's
An
device. He
issue,
can
okay.
log off and then log on back, and then he'll be able to hear us clearly. Or he
Okay,
gets an
okay.
issue either his network or his device. Yeah.
Okay, so there's this issue. I feel that people like landlords, when they want to rent the property, they collect what you call agreement and commission.
Mm-hmm.
And at the end of the day, they don't give their tenant any agreement. Now, so how do you address that kind of the situation at one side? Then what is the guideline in the law concerning tenancy agreement, and what information should be included in tenancy agreement? So firstly, I'm asking about the fact that tenants don't receive tenancy agreements even after they've paid for it. So what should, how do we address that situation? And then afterwards, what is the guideline in the law concerning tenancy agreement, and what information should be included in the tenancy agreement?
Okay, yeah. So there are quite a number of things there. So first is what should happen with tenancy agreement. So first is if you pay for a tenancy agreement. So when you are moving to a house, there are a number of fees you have to pay. The first is rent. Then the next is what we call the agency fees for the agent that got the house for you. Then you have the legal fees, that they call it agreement fee. Then some can give a caution deposit. Then if the house has some services, they can collect a service charge. So each of those fees have rules that guide them. So the one you're talking about now is the tenancy agreement.
Yeah.
What happens is the tenancy agreement, when you pay that as the tenant, you are entitled to get a tenancy agreement once you pay agreement fees. That tenancy agreement has to be signed by a lawyer called to the Nigerian bar, and his legal seal has to be on that agreement. So if any of those conditions are not met, you as a tenant, you have a right to report to the NBA, stating the landlord's name and explaining to them that a landlord collected an agreement fee from you and did not give you a tenancy agreement. There are some times where the agent can draft a tenancy agreement and he can give it to you as an agreement. Once legal fees are charged from you, then it's only a lawyer called to the Nigerian bar that can collect the fees for that. So if it's an agent that drafted it and gives you that tenancy agreement, you can report to the NBA as well that a non-lawyer is collecting fees meant for a lawyer. Also, we have instances where it can be drafted and then they just put another seal, they're not a lawyer seal. So those are things that tenants have to check with that. Once you pay for tenancy agreement, you have to get a tenancy agreement signed by a lawyer that's been called to the Nigerian bar. There are instances where the tenant doesn't even get any agreement at all. Then what occurs is that tenant has a right to request for sale from the landlord, especially if he has paid for tenancy agreement. And like I said, if none is given, he can report to the NBA branch closest to the house to tell them that there's a landlord who's collecting tenancy agreement fees and not issuing tenancy agreement. Now, we have some people who give you different, but however, if the landlord does not collect agreement fees, he can still give you an agreement not signed by a lawyer. So if you only collect agency fees and collect caution deposit and only collect an agreement fee, he can do an agreement between the two of you, and that agreement is still binding as long as it doesn't collect tenancy agreement fees. And so that document must contain first the name of the landlord and no tenants, contain the amount you paid, what you paid for, the duration of that of rent, and what rights you have as a tenant and what rights as the landlord. So probably the right to not to sublet, the right not to sublet. You can reserve the right to come to the apartment to see it from time to time. So those are things that the landlord can put in that agreement between the two of you. So since there is no tenant, since you need benefits for him, he can just draft something between the two of you to show that two of you have entered into an agreement, and that document signed by both of you is binding. However, if you pay agreement fees, then he has to engage a lawyer called to the Nigerian bar to prepare an agreement. Thank you. You are muted.
Yeah.
Okay.
Okay. Yes. So I move to the next question, and it comes to eviction, notice to quit. Now,
Yeah.
some tenants often believe that they are entitled to 6 month notice if they are yearly tenant automatically.
Mm-hmm.
And place of the tenancy agreement when it comes to can you still hear me?
Yes, we can hear you, but it's breaking. But
Can you
I
still
can
hear
piece
me?
together what you're trying to say. Yes, we can hear you now. The network is better.
Okay. So the question is that where is the place of the tenancy agreement and what the law says as regards notice to quit, which tenancy agreement and the other believes that is the law. So what do you have to say as regards eviction, notice to quit?
Okay, yeah, though the line was breaking, I'll just summarize what I think the question is asking. So you're asking that as regards regarding eviction, which supersedes the tenancy agreement or the tenancy law of that state,
Yes.
regarding when it comes to notice to quit and then eviction in general. Yeah, so basically, when it comes to notice to quit, there are rules regarding notice to quit. And so one of it is, and so the two of them work hand in hand regarding what happens when eviction was to occur. But the starting point is the agreement between the parties. So that is the starting point, and that's why the tenancy agreement holds sway most times. But if the parties do not expressly state what would happen, then the tenancy law of the state where the house is what operates. So, but if the parties have a clear term as to what will occur in terms of eviction, then what the tenancy agreement states is what supersedes. But if the parties did not state it clearly, or there's ambiguity as to what is stated there, or there's confusion as to it, then the tenancy law of that state is what supersedes. And that's why I can say tenancy law most times will say subject to the agreement between the parties, knowing fully well that the parties can have an agreement different from what the tenancy law says. However, if the landlord and tenant do not have any tenancy agreement at all, or the tenancy agreement did not state what should occur, then that's when the tenancy law of that state now kicks into effect. So there are some general rules that apply to notice to quit an eviction. So one of it is determined by, like I said, the terms between the tenancy agreement and secondly the law. So if, for example, the tenancy agreement states the amount of months for notice to quit, then that month in tenancy agreement states it. But if it's not stated there, then tenancy law occurs. And if for a tenancy, you have to also check for there are different kinds of tenancies, and the type of tenancy you have will determine what laws will kick into effect for notice to quit. And I'll explain. So, for example, people think that once you are paying your rent every year, automatically you are a yearly tenancy. Yeah, yearly tenant. I mean, that is not as clear as it is. So, your tenancy agreement, for example, can say you are a tenant for a 1-year fixed term. That makes what in law we call a fixed term tenant and not a yearly tenant. So even if you are paying your rent every month, you can still be a tenant for a fixed term. And so that is one thing that I see a lot in practice. People choice of tenants because they pay every year. They think that they're yearly tenants. But you can be a tenant for a fixed term and be paying your rent every year. And I'll explain further as to why, as simple as those things is, there are a number of things that can come into play in that regard. If you are paying your rent, if you're a tenant for a fixed term, the tenancy agreement one will say that tenants for a fixed term. Then two, every time you renew your rent, your receipts that your landlord or the caretaker or the agent will give you will state there that you are paying for another 1-year fixed term tenancy. So even if you are paying every year and you are paying for a fixed term, that means you are a fixed term tenant. And what that means in law is that you are not entitled to 6 months notice to quit, where your tenancy comes to end by operation of the law. So once your term of years expires, your tenancy has expired. And so what the landlord can give you just 7 days notice. And then after the 7 days notice, then he would now just give you, it will now just take the matter to court for the court to eject you. So the fact that you are paying every year doesn't mean you're a tenant, you're a yearly tenant. But if you're a yearly tenant, you're entitled to 6 months notice to quit. If you're a half-yearly tenant, you're entitled to 6 months as well. However, what determines that again is also how you pay your rent. So you can pay your first rent 1 year in advance. And if, for example, after that 1 year, you say, sorry, I don't have the money to pay for another 1 year, and then you now pay for 6 months, technically you have made yourself an half-yearly tenant. And so if you say, I don't have money for 6 months, I don't have money for 1 month, and you pay 1 month, you have also made yourself a monthly tenant. And so you only be entitled to 1 month notice to quit and no longer the 6 months that a yearly tenant would have. So you also have to understand that there are some things that can determine your kind of tenancy. So the fact that when you entered, you were a yearly tenant does not mean that you will continually be a yearly tenant entitled to 6 months to quit. If during the tenancy, after your first year you entered and you paid for 1 year upfront, you now paid for 1 month, and you're now paying for 1 month, you're paying for 3 months, and telling the landlord, please, let me pay for another 3 months, let me pay for another 3 months. You are technically a quarterly tenant entitled to 3 months notice to quit and no longer a yearly tenant. So that's why all these facts play into being. And many times some tenants will come and say, oh, my landlord is very wicked. And when you now hear the facts, you realize that no, his lawyer advised him appropriately, and that is you're paying every month automatically made you a monthly tenant, and so you're no longer entitled to 6 months notice to quit, and the 1 month notice to quit you're given is valid, and you can be legally taken to court. So those are also some things that tenants need to understand regarding eviction and notice to quit vis-a-vis the tenancy agreement and what the law says. I hope I've been able to answer the question as exhaustively as possible.
Okay, yes, you have. So another question from that angle is the fact that some tenants believe that it's until after their rent has expired, and that's when the landlord can serve a notice to quit. So if a tenant is from January to December, they believe that after that December, that the landlord must serve the notice to quit for maybe another January to December, to June. So
yeah. So
did you get the question?
I was able to. Yes, I did.
Okay.
Yes, I was able to get the meat of the question. So, which is and the question was regarding the tenancy, the notice to quit should be served during the tenancy, or it can be served after. So basically, that's also another misconception that quite a number of tenants and even landlords mistake. And so what happens is when there is so prior to 2011, most of your notice to quit has to end with the anniversary of the tenancy. But since the tenancy law of Lagos 2011 and a number of other states have adopted that now you can start notice to quit at any time. But what the law says is that you must give it, if the tenant is a yearly tenant, you must give the tenant 6 months notice. So the 6 months notice can either run concurrently with the tenancy, or it can be after the tenancy or during the tenancy. How do I mean? So for example, your tenancy is January to December. Your landlord can validly give you a 6 months notice to quit from June to terminate in December. That is a valid 6 months to quit. The landlord can also give you a 6 months to quit to start from October to end the following year, March. As long as it is 6 months notice to quit, it is valid. You can also give a notice to quit to start in December or January to end in June. That's also valid as long as it gives you 6 months notice for you to quit the property. That notice to quit is valid. And so there are many tenants that think it must run concurrently with the tenancy, or it must be after. And even there are some that believe that it must be rent-free. There is no law that says your landlord should not collect rent for every day you spend in the apartment. I said that that's the misconception many tenants have, that yes, you must, once you're staying in the house, then you have to pay the rent of that apartment. However, there are times when the landlord, out of his magnanimity, can say, I would not want to give you a notice to quit, at the same time force you or compel you to pay rent for that period, since you're looking for another apartment. And I'll let you give rent free for 6 months. After 6 months, leave and then go elsewhere. That doesn't mean that it is a right of the tenant to live rent free. The landlord can, out of his own goodness of his heart, give you that 6 months period rent free. He can. But if the landlord insists on you paying, it is not a wicked landlord. The law permits him to collect money from you while you are in the apartment, because the reward of every landlord is rent, and so you have to pay rent while you're still in an apartment. We can always beg and plead, and then he can, out of his goodness of his heart, give you those period of time free of charge. It's not a right, but you can request for it, and if the landlord gives you, you can have it. But don't insist that you must have any period free in staying in anyone's apartment. So I think I'm able to fully answer that question.
yes, very well said. That's very important to know that if you have an extension, the tenant should not think that you're going to live in that place for 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 free. All the best you can do is to plead that the landlord, please just give me this more time, or let me not pay this amount so that I'll be able to gather the money to be able to pay another, for the rent, so the house I'm looking for. So another question that's from that from the rent issue has to do with the minimum number of rent a landlord should collect from a tenant. That is one area that is you say a lot of landlords just receive 2 years, and they would say that it's not the government that built house for them and all that. So what do we have to say concerning that?
Yeah. So for Lagos, it's clear you can't collect rent for more than 1 year. Though I've seen quite a number of people in practice try to beat that law. Some will say, oh, they are collecting it for 24 months in total, or you use different words around it. But by the tenancy law, the highest you are to collect is for 1 year rent. If it's a residential apartment in Lagos, we read the tenancy law occurs. So you have to just collect for 1 year rent is the maximum a landlord should collect. And even right now, Lagos is trying to test the policy for monthly tenancy, but they are trying to test that because, like we know, sadly, rent default is very high even in Lagos, and so there's a way to bring it. So technically, how the policy is intended to work is that the amount to be paid to the land. So it's pretty much like some kind of loan, rent, such that the landlord will be paid his rent in advance for a year, but the tenant will be paying monthly. And so they're currently testing it with tenants who are working in meaningful employment to see how that system can